Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer in Alabama. And I received something today that I thought you guys might have some interest in. And you can see up here in the upper right hand, this was filed today, actually this morning, December 28th. And I've redacted the information that would relate to my client. And this is an affidavit from LVNV Funding LLC. And they have sued my client. And so now this person that's offering this affidavit is saying, here's some evidence or some information I want to communicate to the court. And I thought it might be good just to go through here and let's take a look at it and see, does this look legitimate? Is this very suspect? What's the deal here? So let's start off. First of all, I'm an authorized representative for the current owner, LVNV Funding LLC. Well, that sort of assumes that they are the current owner. We just had a video, I think it was yesterday, on the difference between owing a debt and then a debt buyer like LVNV owning a debt. So this is assuming that they own the debt. Now, we don't make that assumption, but they certainly do. And notice it says I'm an authorized representative for LVNV. Here's what it doesn't say. I work for LVNV. I'm an employee for LVNV. I've been working for LVNV for a dozen years. It doesn't say that. Now, part of the reason is LVNV has no employees. And so this person is going to work for most likely a company called Resurgent. But they don't want to say that because then that kind of raises some questions in the judge's mind about, well, wait a minute, you don't even work for this company. And then, of course, they don't have a witness at trial. At least they never have in our cases. And so then the lawyer's saying, well, Judge, Resurgent and LVNV, they're almost the same thing. But now, of course, when we sue them, they go, oh, totally different companies, totally separate. Don't ever lump them together. So that's just the first part here. All right, well, let's look now at paragraph 1. I have personal knowledge regarding plaintiff, that would be LVNV, plaintiff's creation and maintenance of its normal business records, which includes the computer records of its accounts and corresponding receivables. This information is regularly and contemporaneously maintained during the course of plaintiff's business. Okay, that's just kind of regurgitating what the law would typically say for under hearsay for a business record exception. Okay, so there's nothing particularly interesting there except to point out that this person, again, gives us no indication as to why they have this personal knowledge. How do they have it? What's their experience? When did they get it? We have no idea because the affidavit doesn't tell us. And if we look down here, we see this is a Felicia Richardson, signed this back in August. And this looks like South Carolina. And so it was filed 4 months later in this case. All right, so let's look here at paragraph number 2. This is where it starts to get interesting. In the regular course of business, plaintiff acquires revolving credit accounts, installment accounts, service accounts, and or other lines, credit lines, or obligations. Notice this next sentence right here. I don't know if my little cursor will come up, but it's this very next one here. The records provided to plaintiff in connection with such acquisitions are represented to include accurate information provided by the original creditor and or subsequent owners. And that information is incorporated into plaintiff's business records. Such information includes debtor's name, social security number, account balance, identity, original creditor, account number. Well, let's go back. So it says, hey, the records that are provided to LVNV are represented to include accurate information. Well, that's amazing because a lot of the purchase agreements specifically say there is no representation that these records are accurate. But here we have this person in an affidavit swearing under oath that, hey, when we get these records, there is a representation that this is accurate information. And this is provided by the original creditor and or subsequent owners. Well, now, of course, if it's a subsequent owner who's saying it, but the original creditor didn't, well, then the subsequent owner has no basis. I mean, I think I used an example the other day of if I sell you the Golden Gate Bridge, you're like, hey, I bought it. And, John Watts said it was a legit deal. Well, if I don't own the Golden Gate Bridge, and I don't, then I have no right to sell that to you. Well, if the original creditor says, hey, here's some accounts, but we make no promise, no representation, and then the first debt buyer sells it to a second debt buyer and says, we swear to you these are accurate. Well, it doesn't matter because they don't know if it's accurate. Only the original creditor would know if it's accurate. So this is one reason why we need the purchase agreement. And if there's more than one debt buyer, we need every single purchase agreement going all the way back to the original creditor. Does that make sense? I mean, we've got to see, what did that original creditor say? Because if the original creditor says, we don't make any promise, any representation, any of this information is accurate, well, then how could any subsequent debt buyer who sells it to the next debt buyer say that these are accurate? And this is part of why they don't want the purchase agreement to come in, because they just want to say this stuff in affidavits, even when it's not true. Now, is it true here or not true? I don't know. I haven't seen the purchase agreement. I suspect I won't see the purchase agreement. But, if this goes to trial, you can imagine that we're going to be, definitely bringing that up with the judge. Judge, look, they're making this statement about what the purchase agreement says. And we have a concept in the law called the best evidence rule. And the best evidence rule traditionally said you have to put in the original document. A copy is not sufficient. Now, that's a little bit of sort of from the time period of people like, handwriting copies. Well, maybe they made a mistake. Okay. Now we have photocopy. Of course, now we can change stuff in PDF, but where this really comes up is not so much in, is this an original or a copy, but it's when people want to testify about the contract. Let me tell you the terms of the contract. Well, no, the best evidence is not you yapping in the witness stand. The best evidence is, let me look at the actual contract. So see, if we're arguing about, was this person married, was Bob married to Sue? Okay. And you might say, well, how, why would that come up? Well, it comes up in wrongful death cases. Okay. So Bob has been killed in a wrongful death, and now Sue comes up. Nobody's ever met her. She says, oh, by the way, I was married to Bob. He's my husband. And so now I have the right to bring the wrongful death lawsuit. Well, you can imagine we're in front of a judge and she's saying, oh, yeah, we were married. And the judge says, well, let's stop showing me pictures and Christmas cards. Show me the marriage certificate. Well, I don't want to do that. I just want to talk about, well, no, see, the best evidence would be the marriage certificate. It would be even tax returns showing that you're filing, married, joint filing or whatever. So here, the best evidence is not, who is this, Felicia Richardson, talking about what the purchase agreement says. It's just, let's look at the actual purchase agreement. Then we don't have to rely on what somebody is interpreting it. And by the way, if she is testifying live, we would ask her the question, so tell me how many times you have read the purchase agreement that relates to my client's account. Well, I don't remember. Well, have you ever read the purchase agreement? I don't think so. Have you ever read any purchase agreement? No, they won't let me. That's how this thing plays out. So this paragraph number 2, sort of crazy here. Okay. So best evidence rule, the purchase agreement, and they got big problems with this. Now, let's look here at number 3. Based on the business records maintained on account, blah, 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 and its corresponding receivables here and after the account, which are a compilation of the information provided upon acquisition and information obtained since acquisition. Now, if you can explain that sentence to me, that's fabulous. Okay. The account was originated on this date by Credit One Bank, represents a valid obligation of X number of dollars. Okay. So what is all this sort of nonsense talking about? Well, in a big picture, This is really talking about, again, those two concepts in our previous video about you owing the debt and the debt buyer owning the debt. So see, they say in paragraph number 2, hey, we bought this debt. Okay, that's what we do. And then we'll see in paragraph 4 and 5, they say we bought this debt. Okay. And then they're going to say, well, here's when you took it out, and this is how much you owe, so you really owe it. But, this sentence is unnecessarily complicated, which makes me suspicious when I see stuff like this. So we've got this account and receivables. So those are two separate things. We have an account and a receivable. And then they talk about a compilation of information provided upon acquisition. Well, we'll see in a minute who they bought it from. Here's a hint. It wasn't Credit One Bank. And information obtained since acquisition. So that would mean that LVNV bought this debt, if you believe them, from somebody. And then they've done some research and they've gathered some information. And all that tells them that the account was originated on April 26, 2015. Yeah, there's nothing that they got after acquisition that tells them that. Okay? And it represents a valid obligation of, again, it's sort of gobbledygook here. But here's a significant thing. Those purchase agreements sometimes will really distinguish between the receivable and the account. The receivable and the account. The receivable is the actual money. Okay, so like we have accounts receivable, that's money that's owed. And then you have the actual account here. And not all purchase agreements, but a lot of these purchase agreements will separate these things out. Sometimes they'll say we're selling the account to company X and the receivables to company Y. Well, that's kind of weird, isn't it? Like, well, if you don't get the receivables, what are you buying? It's a great question. And again, we have to look at these purchase agreements to figure this out. But it certainly raises some questions here about what's going on. Now, let's look at number 4. This is very interesting. Plaintiff is the current owner of the account. Well, current owner would mean they're not the original owner, right? But they say, hey, now we own the account. So remember, they show that you owe the original creditor. That's only half the battle for them. All they've done is show that you owe the debt. Now they have to prove they own the debt. And that's what LVNV is trying to do here. Hey, we own it. And our business records indicate that subsequent, in other words, after the account's origination, other owners of the account included, whoa, look at all these companies here. So it went from, if you believe LVNV, it went from Credit One Bank to MHC Receivables LLC. There would be a purchase agreement between Credit One and MHC Receivables LLC. Where's that purchase agreement? I promise you LVNV does not have that. And then MHC Receivables LLC sold it to FNBM LLC. Well, there would be a purchase agreement. They didn't do it on a handshake. They didn't write it on the back of a napkin. Hey, we're selling you $50 million worth of debt for $5 million or $2.5 million. No, there's a contract. It's a long contract. Purchase agreement is going to be 30, 40, 50, 60 pages long. Okay. But then it doesn't stop there. Then FNBM LLC sold it to Sherman Originator Roman numeral 3 LLC. Well, who's that? Well, that's in this sort of family of LVNV companies. Now, again, when we sue them, they're very quick to point out, oh, these are totally separate entities. You have to respect the corporate formalities between all these. We have assets sort of tucked away in all these different companies, and you can't combine it. So they're very quick to say, hey, these are absolutely separate companies. Now, when they sue, they want to kind of lump them all together. Okay. So again, it goes from Credit One to MHC, from MHC to FNBM, from FNBM to Sherman Originator Roman numeral 3 LLC. Again, there'd be a purchase agreement. But that's not all. Then Sherman Originator Roman numeral 3 then sells it to Sherman Originator LLC. Totally separate company. And then that's when LVNV says, and that was the last company before us to get it, which means Sherman Originator LLC then sold it, which would mean there's a purchase agreement, to LVNV Funding LLC. Now, what they're not saying in this affidavit, but based on my experience, the truth is there's another company in there. It was sold from Sherman Originator LLC to Resurgent, and then Resurgent sells it to LVNV. They kind of left that step out, okay? But let's just take what they say here. Let's think about how many purchase agreements. So a purchase agreement from Credit One Bank to MHC, that's one. And then to FNBM, that's two. And then the Sherman Originator, three. So that's three purchase agreements. And then Sherman Originator, Roman numeral 3, to Sherman Originator, that's 4. And then Sherman Originator LLC to LVNV, that's 5. And really, I think there's a 6 in there. But we got 5 purchase agreements. Okay? Now, just think about it this way. Sort of visualize a timeline in your mind. On the left is the original creditor. On the far right is LVNV. Okay? And so you draw a line from from Credit One Bank, the original creditor, to MHC. Now, if Credit One Bank only sold them the right to collect the money but not to sue, well, then MHC can't sell anything more than they had. Okay? It would be like me selling you, let's say I had a lot on a lake, and I said, I'm going to sell you 1/10 ownership of that lot. And you go, great. And then you turn around and sell it to your brother-in-law and you say, I'm selling you the whole thing. Well, no, you don't have the whole thing. You only got 1/10. The most you can sell is what you bought. Well, the most MHC Receivables can sell is whatever it bought. The most that it can represent the accuracy of is whatever Credit One Bank represented the accuracy of. Okay? In most of the purchase agreements from a company like Credit One Bank, not exactly a sterling example of a fine institution, in my opinion, they are not going to represent that, oh, everything we're giving you is the gospel truth here. No, they're going to say, hey, you're buying it as is, no representation, good luck with it. Well, that means MHC can't sell anything with sort of a greater representation than that. And so that goes to FNBM, which goes into Sherman Originator 3, which goes to Sherman Originator, which goes to LVNV. You see the difficulty these guys have? The more transfers there are, it's just, there's more opportunity for them to make a mistake, for there to be errors. And look, LVNV chose to buy this debt. They knew it had been bought and sold all these times. And so it knows there's greater risk. As you can imagine, when you're buying it like number 5 or 6 in line, you're hardly paying anything for it because it's complete garbage. Okay? And so then they say in paragraph 5, on this date, all ownership rights in the account were assigned to, transferred to, became vested in plaintiff, including the right to collect the current balance owing a blank plus any legally permissible interest. Well, again, that's going to be from Sherman Originator to almost certainly Resurgent, who then transfers it to LVNV. But again, they have to prove all those steps. We don't assume in court. We don't go, well, LVNV, fine, upstanding company. I bet that they really bought. No, we don't do that. We say you have to prove that you own the debt, which means you have to prove exactly what you bought from Sherman Originator. And then Sherman Originator has to prove exactly what it bought from Sherman Originator, Roman numeral 3. It has to prove exactly what it bought from FNBM LLC, which has to prove exactly what it bought from MHC Receivables LLC, which has to prove exactly what it bought from Credit One Bank. That's a whole lot of proving. Okay? And that's their problem, because they chose to buy this debt that had been passed around half a dozen times, and now they're suing on it, and they just want to gloss over and say, hey, we own it. Remember this, if we go back to the top, the current owner, how do they know they're the current owner? They go, oh, well, we bought it from Sherman Originator LLC. Well, who'd they buy it from? Well, we don't know. It says, all these other companies. So anyway, that's the deal here with paragraph 5. And then 6, defendant's not a minor or mentally incompetent person. And then number 7, they just say, hey, we think this amount is owed and there's no offsets or payments or credits. And then here we have, I affirm under penalty of perjury that the above facts are true and correct to the best of my knowledge based on the plaintiff's business records. To the best of her knowledge. So that's very interesting. That may come back and be a problem for her and for LVNV. But this is certainly one way to look at these affidavits. And, there are other things that we can bring up. I'm not going to go through everything on a public video, but hopefully this gives you a good idea of just kind of taking it piece by piece, very slowly, very methodically, and saying, okay, is this sentence true? And what does this mean? Like here, the expression, the elephant in the room, it's kind of like, well, the elephant in the room nobody's talking about. Well, if you visualize that, imagine you're in a living room with somebody and there's this giant elephant and everybody's like, I don't see the elephant. Well, eventually the elephant starts going to the bathroom. Like you can pretend it's not there, but I promise you'll know it's there. Okay. So the elephant in the room, there's several, but the big one is look at all these transfers, all these different companies. Where are all the purchase agreements? Where's all the proof? All the details of those transactions. They won't say a word about it in court, at least in my experience. And I've been defending against LVNV since, 2007. Been suing them since about the same year. And look, they've got a business model of buying stuff that is junk, and they know it is when they buy it. And, they've found a way to be profitable doing that. Hey, it's America. If you can make money, that's great. I think you ought to make money legitimately and within the bounds of the rules. And if they can collect this without violating the Fair Debt Collection Practices Act, the Fair Credit Reporting Act, then God bless them for that. But if they cannot do that, then they shouldn't be surprised or act upset when they get sued about this. So hope you found this helpful. If you like this type of stuff, I can do more of this where we actually go through the complaints or these affidavits or the bills of sale and things of that nature. Just let me know in the comments if you like this. And if you have one that you want to send to me, just redact the information that you don't want public. And look, pretty much all of this stuff is going to be public record. It's in the court system, but you may not want, your name out on a video, but just, send it to me however you want me to use it. And you can send that to me at john@wattsherring.com, or you can just contact us through our website, alabamaconsumer.com. And just keep this in mind. I represent people in Alabama who are sued. If you're sued in another state, I can't represent you. I can't advise you on what to do. You need to find a local lawyer for that. Now, if you're suing LVNV, that's a different matter because we can sue LVNV in Alabama. Okay. But, don't reach out and think that I'm going to go through your documents and tell you what to argue and appear in court for you or something like that. But if you want me to take those documents and make a video about it and share that publicly, then I'll do just like I did with this one. And hopefully that will give you some ideas. And okay, guys, well, listen, appreciate you watching this, and I'll catch you tomorrow. Have a good one. Bye-bye.